Thank you for tuning in to my research case study of defamation. I am Jill Morgenthaler, and this is a review of the New York Times Company versus Sullivan case. Now, to summarize this case, Sullivan, the plaintiff, sued the New York Times Company, the defendant, for publishing libelous material. In an ad titled "Heed the Rising Voices" that the New York Times Company published, there were alleged incidents involving peaceful protesters and police brutality. Now, Sullivan believed that the alleged police brutality damaged his reputation because he was Commissioner of Public Affairs of Montgomery, Alabama. And as Commissioner of Public Affairs, he oversaw the police, fire, cemetery, and skills departments. And because the information led to the police or the law enforcement, he thought this damaged his reputation. Now, the ad included elements of law enforcement meeting students participating in nonviolent demonstrations with an unprecedented wave of terror, including padlocking a dining hall to starve students into submission, expelling leaders of the protests, and arriving to protests with shotguns and tear gas. It also alluded to the mistreatment of Dr. Martin Luther King, including police bombing his home while his wife and children were at home, and arresting Dr. Martin Luther King 7 times for things like speeding and loitering. Now, to prove libel, you have to prove the publication of the content, the identification of the plaintiff, defamation, fault, falsity, and injury. Now, the ad "Heed Their Rising Voices" was published in the New York Times on March 29th in 1960, and it's a very well-known publication, so chances are more than one person saw this ad other than Sullivan, and that needs to be proven for the publication aspect. For identification, you have to prove that the article is of or concerning the person or the plaintiff. And although Sullivan was not named, the ad referred to the police several times. And as Commissioner of Public Affairs, Sullivan said this implied his involvement. Now, Sullivan and 6 other Montgomery residents said they did read some or all of these statements as referring to Sullivan in his capacity as Commissioner. As far as defamation, a statement that holds a person up into public hatred or ridicule or scorn, these activities mentioned in the ad would defame any participant in those activities. As far as fault, neither the manager of the advertising department nor anyone else at the Times made an effort to prove the accuracy of the ad, and Sullivan did ask the Times to retract the statement. However, the Times did refuse. To prove falsity, Sullivan did go over some of the alleged issues and clarified what actually had happened. Like, students were not barred from eating, but they were the students that did not sign pre-registration applications or had they purchased temporary meal tickets to be able to eat in the dining hall that day. And he also said that police were not called, nor did they ring the campus in connection with the demonstration, and he did also clarify that Dr. King was only arrested 4 times, and that battery was denied by one of the arresting officers. As far as injury, Sullivan made no effort to prove that he had suffered a loss as a result of the ad, and this needs to be done to prove libel. Now, proving actual malice, since Sullivan is a political figure, he does need to prove actual malice. So to do so, you have to prove that the information, did it come from a reliable source? Are the situations probable? Were known facts omitted? Were there warnings that the information was false? And were these warnings neglected? As well as, were there any inconsistencies in the story ignored? As far as the information coming from a reliable source in this case, the ad was submitted to the New York Times from a New York ad agency with a letter from A. Philip Randolph, who was a committee chairman, and the Times saw him as a respectable person. And the letter was sufficient proof of authorization for the information. Are the situations probable? In this case, given the time and the situation, there was a lot of brutality and a lot of terror in the civil rights movement, so the situation could be probable. As far as known facts being omitted, warnings that information was false, and inconsistencies in the story, all of these things were covered because the Times did not have a cause to believe that any information given to them was false due to the letter. Sullivan did ask the Times to take down the ad. That might be considered a warning that the information was false. However, the Times did rebut by saying, how can you tell that this information is about you? Now, the Supreme Court did decide in favor of the defendant of the New York Times, and that was because actual malice could not be proven. And even though the defendant failed to retract the advertisement or check facts, the libelous statement was not of or concerning the plaintiff, according to the jury. Now, states or public figures are prohibited from being awarded damages for libel, as well as there is an aspect of freedom of speech that gave the New York Times the right to publish the criticisms of the officials and of any political official. Now, what this case taught me as far as my PR professionalism and my media interactions and release of information is to remain honest and really try to strive away from defamation, libel, slander, and disparagement. And the best way to do so is to avoid getting yourself into presenting misleading information, headlines, photos. Identifying people correctly is a great way to avoid these types of situations, and really editing my content to just make sure that I'm portraying everything in the correct light and retaining notes and recordings of interviews and things like that to make sure that I get the information to the public correctly. Now, as far as handling defamation of a client or a business that I'm working with, I really have to make sure to take in consideration the source. Who made the statement? What was the nature of the comment? What was the damage done to the company's reputation? And what are the best ways to handle it going forward? Can I handle the situation and correct the statements via social media or media contacts, maybe a press conference, those type of things? And the last resort would be to file a lawsuit. Now, that would shed our image very poorly in the public light. I appreciate you listening to me today, and I hope you have a wonderful day.